Have you ever watched a courtroom drama and wondered how they go from a messy he said, she said situation to an actual final verdict? Well, the secret isn't just about flashy lawyers. It's about a set of rules that are, quite literally, the lifeblood of any legal case: evidence law. And that's what we're going to break down right here. It all really comes down to this one simple question, right? When you have two sides telling completely different stories, how on earth does a court decide what's true? The answer, as you've probably guessed, is evidence. All right, so here's our game plan. We're going to start with the absolute basics. What even is evidence? Then we'll look at all the different shapes and sizes it comes in, and we'll unpack the critical difference between direct and circumstantial evidence. After that, we'll tackle the all-important question of who has to prove what. And to wrap it all up, we're going to explore a landmark case that gave us what's known as the golden thread of justice. So let's dive right in. What is evidence? Well, at its very core, it's the set of building blocks for any case. It's all the individual pieces of information that, hopefully, when you put them all together, create a clear picture of what really happened. The textbook definition is pretty straightforward. It's any information that's put in front of the court, and its one and only job is to help the court figure out the truth behind the facts in issue. The big questions that have to be answered to decide the case one way or the other. The best way to think about it is like a giant jigsaw puzzle. Every piece of evidence, whether it's something a witness says, a signed contract, or a physical object, is just one piece of that puzzle. The court's job is to see if all those pieces fit together and if they form a complete, convincing picture of what went down. Okay, so if evidence is like puzzle pieces, what do these pieces actually look like when you walk into a courtroom? Let's break down the main forms of proof. These are pretty much the main categories you're going to see. You've got oral evidence, which is testimony from witnesses. You've got documentary evidence, things like contracts or emails. Then there's real evidence. We're talking physical objects, like the actual weapon. And of course, you have admissions or confessions from the people involved. Now, the one you see most often, especially in the movies, is oral testimony. That's when a witness gets on the stand and tells the court what they saw or heard. But it's not just about telling a story. The real action starts during cross-examination. That's when the other side's lawyer gets to poke and prod and try to find holes in their account to see if it holds up. Now, not all evidence is created equal. There are really two main paths the evidence can take to get to the truth: the direct path and the circumstantial one. And understanding the difference between these two is absolutely crucial. Okay, so check this out. Direct evidence is the smoking gun. It proves a fact without needing any leaps of logic. The witness says, "I saw him stab her." Boom. Done. Circumstantial evidence, on the other hand, it needs an extra step. The witness says, "I saw him running away from the scene holding a bloody knife." See the difference? The court has to infer that because he was running away with a bloody knife, he must be the one who did it. They have to connect the dots. So, who actually has to do all this proving? It's not a free-for-all in there. The law has very strict rules about who carries the responsibility to make their case. And this whole concept is called the burden of proof. The burden of proof is exactly what it sounds like. It's the responsibility a party has to present enough evidence to support their claims. It's usually broken down into two little parts: the legal burden, which is the big overall responsibility to prove your entire case, and the evidential burden, which is more about just presenting enough evidence to get the case off the ground in the first place. And this is where things get really interesting. In a civil case, like a lawsuit over a contract, the plaintiff, the person suing, only has to prove their case on the balance of probabilities. That just means they have to show it's more likely than not that their story is true. 51%. But in a criminal case, the game completely changes. The stakes are someone's liberty, so the standard is way, way higher. The prosecution has to prove guilt beyond a reasonable doubt. It's a much harder bar to clear, and it's designed that way to protect the innocent.
That incredibly high standard in criminal law, beyond a reasonable doubt, well, it didn't just appear out of nowhere. It was cemented by a landmark case that created what we now call the golden thread of criminal justice. Let's get into the story behind it.
Okay, I want you to picture this. The year is 1935. In England, a 21-year-old farmer named Wilmington is on trial, and he's facing the most serious charge you can imagine: the murder of his estranged 17-year-old wife, Violet. Now, the facts of the case, they look really, really bad for him. His wife leaves him, and that same day, he steals a shotgun, saws off the barrel, goes over to her mother's house, and she ends up shot and killed. His story? He claims it was all a tragic accident. He says he went there to try and win her back and was actually threatening to kill himself, not her, when the gun went off by mistake.
So here is the legal bombshell. At the trial, the judge tells the jury that because Violet is dead, and because Wilmington admits his gun fired the shot, the law just presumes it was murder. And he said the burden of proof was now on Wilmington to convince them it was an accident. Think about that. He had to prove his innocence.
But when the case got appealed all the way to the highest court, they strongly disagreed. And in their final judgment, they delivered this absolutely iconic, unforgettable line. Throughout the web of the English criminal law, one golden thread is always to be seen. And what is that golden thread? It's the presumption of innocence. The court made it crystal clear that the burden of proof is always on the prosecution. It is never, ever the job of the person accused of a crime to prove that they're innocent. All they have to do is raise a doubt.
So what happened? Well, because the trial judge got that fundamental rule completely wrong, Wilmington's murder conviction was thrown out, and his case set in stone a principle that protects every single one of us to this day. You are innocent until proven guilty.
This principle, born in 1935, might seem like ancient history, but it's probably more relevant today than ever. In our age of social media, instant judgment, and public accusations, how do we protect that golden thread? That simple, powerful idea that the burden of proof has to be on the accuser, not the accused. And what happens to justice if we start to forget it?